Now we're going to go on with this marathon-like agenda. When us as organizers, we wanted to structure these 2 days, and one of the things we got was to take the digital asset agents, to invite them and to invite people from in the digital asset world in Alicante, because in Alicante, in Elche, next to Alicante, there's Bit2Me that is very famous. It covered Madrid with advertisements that today it has grown a lot. Juan Carlos will tell us about it. And it is a way of touching, seeing this situation in real life. Because as Ed and Stephen mentioned, we wanted to collaborate with crypto employers, and we want to see their opinion, because sometimes it's hard to find the link between the legal world and the business world. So we wanted to have the opinion of lawyers, to have the opinion of notaries. I'm going to introduce all of them in a minute. Something that's essential for legal certainty, that's what principals are looking for. We've got a representative from the Notaries Professional Association and from the Registrars Professional Association. And finally, in Alicante, we have a stock agency, and they're going to tell us about crypto validation, etc. So it's a way of getting closer to the crypto asset world or digital asset world, because we have some realities such as being able to purchase properties with crypto assets, and Juan Carlos will tell us more about it. At first, we had half an hour. Now we're going to leave it in 20 minutes because it would be advisable to have time for discussion afterwards. So if you agree, I'm going to try to control the time. The structure of the round table is very easy. It's just a question to open up the floor, and it is how UNIDROIT principles is going to affect the commercial and the business reality. So we want you to tell us about it, to give us some context. First of all, we've got Gonzalo Cano Mora, who's the representative of the official association of Professional Association of Notaries in Valencia. And they are the sponsors of this event. That's very important. We're here thanks to them. And that's all. So even if we've got the Prometheus project, we've got some limitations for us to organize events such as this one. So thanks to your support, we're here today. And we are discussing on such a relevant topic. But we've got important limitations, so thank you very much for your support. And it wouldn't be possible without you. First of all, I'm going to introduce, as I was saying, Mr. Gonzalo Cano Mora, representative of the Notary Association, Professional Association in Valencia, in Gandia. He made a huge effort because Ignacio was already mentioning it. You are aware of the situation with the floods in the region of Valencia, so thank you very much for coming, Gonzalo. I don't know if you want to start. Can you hear me? Is it on? I had a short presentation, but it has to have a different format. Here it is. I don't know if I have the pointer. Can I have the pointer, please? First of all, I want to thank the University of Alicante and the organizers for inviting me, because we have the idea of notaries, registrars. They're over there in their offices. They're old people with a mustache, but that was old style. That was old school. At the moment, there are more women than men. But we are really interested in this topic because why? Because it's reality. It's what we see in our offices on a daily basis. People who want to purchase a property with Bitcoin, and we analyze it, and that's it. But I don't know, where do I have to point? When we talk about digital assets or UNIDROIT principles, digital assets, we can say, okay, it can be an apple or it can be a building. So we have to distinguish between different things. First of all, I would talk about crypto coins, cryptocurrency. China already has it, then the EU is thinking about it, then we have crypto coins, the stable coins, that according to Mika is the e-money token. We're talking about dollars or any other stable coin, the asset reference token, such as Tether Gold. And we can use that. This is a general use. They're generally used because they are in a digital framework, native digital framework. Then we have the tokens that are divided into utility tokens. When we talk about works of art, for example, we're talking about utility tokens, and we'll see it later on. Then we have security tokens that are more and more similar to securities. Then we have equity tokens. They are similar to security tokens. And then we have non-fungible tokens, NFT, that are associated to assets outside the digital world. We all know that the MiCA regulation tries to regulate all of this, to control it, to regulate it. And after the MiCA regulation, financial institutions will enter the cryptocurrency market to offer customers funds with all of these financial instruments. The issuance is going to be regulated. If you have stable coins or currency referred to gold, wheat, etc., they have to have an equivalent amount in their accounts, etc. So the MiCA regulation does not refer to financial instruments. And now the European Security and Markets Authority, as Professor Tirado mentioned, as I was saying, the European Security Markets Authority will issue guidelines on the conditions and criteria to consider crypto assets as financial instruments. So we have more and more regulation in the EU, in the States, in Japan, for these crypto assets to be regulated. So why that regulation is against DLT, ledgers. More regulation, more taxes, more money laundering, etc. So that's the situation. So at the moment, when you want to ask for a loan and you are required to have funds, you have to prove that you have a specific amount of funds. Banks would be able to use those assets, crypto assets. I'm going to refer to NFTs. If I transmit an NFT, if I'm transmitting a €5 note, it's €5. But if I'm transmitting a Picasso painting, what do we do? Or if it's my house, that's where we can discuss the link between digital asset and non-digital asset, as it has been seen this morning. Regarding the binding, we see the principle 3 was already mentioned this morning. As for the property transmission systems or transfer systems, there are two big systems: civil law, common law. The Anglo-Saxon common law is the law that tries to solve problems, and civil law is more like preventive. I'm not for or against any of them. When we talk about real estate, we refer to NFTs that are utility tokens. For example, I've got a real estate property and I'm going to distribute tokens. That can give me advantages on that real estate. If I want to build a real estate, I can issue utility tokens, and with them, I'm going to tell the purchaser that he or she can use it for some periods of time, or that he or she has a specific percentage of property. That may lead to execution problems in the future, or also on movable properties, such as a work of art. In the work of art, you can issue utility tokens, and then you are guaranteed that you receive a minimum amount of capital. So at the moment, in civil law, we have the situation that was mentioned this morning. When you transfer a token, there's an underlying contract. It can be an oral contract. It can be a written contract. It can be private. It can be public contract. This written document can be electronic or not. Now, with the EIDAS regulation, which the final version was published 3 months ago, and it defines two new services for quality service provider. There's the ledger. The translation in Spanish is not very good. So here we can see there always has to be an underlying contract. And referring to movable property, there are some assets that have to be transferred in front of a notary, and these are shares, corporate shares. Corporate shares and registered shares. But we are always talking about shares that are not out in the stock market, because in Spain that's regulated by the National Commission of the Stock Market. So technology is evolving constantly, and what was done in the past, signing a piece of paper, now we use DLT technology. So registered shares are transferred, and a contract is signed before a notary public. So here we can say that if a company wants to control the shares via a DLT, that would be possible. It would be possible to do so. But most companies have it in a book, in a record book, to register the change of shareholders. So let's imagine there's a company that says, I want to register my shareholders with DLT technology, no problem. I don't think notaries public should be in charge of that. Any service provider, DLT service provider, could do so. But as it is obliged according to the transmission or the transfer deed, the notary should write down in the deed that the token has been transferred with a code, and that's it. And it would be necessary to add an attribute to the token transmission, like a signature. A public key could be established for a body of civil servants, and the transfer of property would happen at the same time as the transmission of the token. I don't think there's too much problem in that sense. So the transfer of token without a notary, it would be a private document. But it would be an electronically signed document that is only equivalent if it's under a qualified digital signature. That's equivalent to the handwritten signature. But it doesn't turn the document into a public document. A company, how would that work with the current legislation? The company administrator would go to the registry, and then he would state that before the registry of companies that they want to register shareholders in DLT technology. And finally, I'm going to refer to the payment of purchases with cryptocurrency. This is something which was weird 7 years ago, but at the moment it's quite usual for people to say that I want to purchase this with cryptocurrency, and that can be perfectly done. As you pay with money, you can also pay with crypto coins. But the problem is the money laundering problem. Why? Because notary is public. We have to ask where financial assets come from. So if you get to the information, you ask for the know your client. You ask for the corresponding documents, and that's it. What happens if the client doesn't submit it? That he got it via mining, etc. Okay. the corresponding organization would do so, would be communicated all data. So all these subjects, the corresponding subjects, will be informed. As for taxes, when talking about the purchase with cryptocurrency, we have to wonder if we are paying for a price. Because why? These are crypto with cryptocurrency. Of course, people are going to start purchasing things, but there's responsibility. At first, people said this is an exchange because Bitcoin is not an official currency. And this is just an exchange. And the person receiving the crypto coins will have to pay for all the associated taxes. When purchasing the cryptocurrency, the EU has dealt with this, saying that if there's a company purchasing that works with crypto coins as part of the professional activity, according to the code of law, they understand that crypto coins or cryptocurrency is equivalent to money. That's why when we purchase money, we don't exchange. It's not an exchange. And this has been decided by the European Court of Justice, but no judgment has been issued yet. When it is an individual person who sells the asset, the good, sorry. And also when transmitting cryptocurrency, you can receive some money, and of course you have to pay for that money. And you have to declare that you are holding cryptocurrency, if you are paying taxes in Spain, etc. Sometimes people say, I'm going to turn a cryptocurrency into fiat money. That's a way to avoid problems. But the person with the crypto coins has the same problems regarding taxes. And that's all. Thank you very much.
Okay, we're going to move on to Teresa Duriñán. You already know Teresa. She participated yesterday. Teresa, you have the floor. First of all, I'd like to thank once again, as you have thanked us for participating and for helping sponsoring this event, and also owing to your sensitivity to include us or regulated operators in this world, because at the end of the day, I'm a property registrar and movable property, and we haven't seen a token, and there are 1,000 of us, but we're worried about this. We're preparing ourselves to when we find the situation. So my reflection of today is about a particular position that I have, not only as a registrar, but also hosted by the Professional Association, where I'm a member in a project under the European Law Institute that started in 2018 and that finished in a project related to blockchain and smart contracts and securities over digital assets. And in this project, UNIDROIT wasn't really welcome, but we did learn a lot from them. I want to highlight Ignacio's work, but also from Ana Veneciano's work and Luis Gulliver from whom we learned a lot and were our inspiration. Possibly the conclusions of those two projects have a lot to do with the background of each one of the rapporteurs and of the entities in front of which they respond, because in the European Law Institute project, we had to report to the Commission, and as a result, that regulatory work, well, had more weight, if I may say. Principles are perfectly compatible, and in many aspects they're even complementary. So why am I here as registrar, and how do registrars see the principles applied to this world? A registrar is an attorney of people that are absent. If I don't say it myself, it's a special of Mrs. Rottenmeier in the chain of transmissions. We're never there for the contract, as my colleague Notary Public, but everyone that cannot see the contract. And what happens if you're affected by this? Because everything is okay when it happens in the market, of which I don't know anything. But what happens if my savings go there? If the Treasury Department wants to claim that task, what happens with this? So my perspective is very limited, but almost always, both for immovable property or real estate, is the same. And taking this perspective, what do I see, or what do we see? The first thing I'd like to say is that what I love is that they exist. I like collaborative effort. I like the product that it contributes, its usefulness. Why? Because it can be applied. It's a real applicability together with the different member states that wish to apply it, and of course, a little bit invasive, I could define it. What other thing do I like? I like the scope that is quite thin for me. What do I mean by all this? That UNIDROIT doesn't touch very consciously those things that doesn't wish to touch or doesn't know how to touch. We tend to expand too much, and that's a virtue. Sometimes it's better to produce something that, I'm not going to say that is obvious, but clear statements that have defined about facts that can, like for instance, Principle 14 about securities. And a digital asset can be a security. Yes, that's crystal clear, and I think that's a virtue, and that can be transferred to our concepts in our legal system. I like it that they don't talk about transactions of real assets, and this is the main difference with the project that I participated in, where you could deal with that, with the regulation of a link, or how the transfer of a digital asset to a real digital asset goes. They chose to put this out of the scope, and I think it's sensible. I don't see it as a problem. I think it's more effective, and I like it that it doesn't address an exhaustive regulation of something that is not consistent. What would I would have liked that they would be more explicit in excluded dimensions, because they could have defined the sectors that they wish to be out of the regulatory. We left, when I was working, the real estate was left aside. In the explanations, they leave aside consumer law and other things. Maybe we could have been more explicit. Yes, maybe, but I'm not going to get into detail. And the scope, I said that the scope is thin, and that is consistent with the initial proposals. But the thing is that when they say that they don't touch, well, I wouldn't say proprietary right in Spanish, derecho a la propiedad. I would call it more patrimonial. Well, there are two words for proprietary rights. These are intrinsic matters for each state. In a state as divided in competencies as Spain, I depend on my constitutional regulation owing to different principles, depending on our central government. In fact, that we're not that divided, and we have been distributed in competences in the different regions, have decided to keep that matter as a joint matter, maybe introducing principles 15 and 16 is kind of extra limitation. Is it necessary for other more global fields? Well, maybe yes. And they could be more protected, yes, but, well, it depends. Theoretically, the principle in UNIDROIT principles want to leave this aside, and that is said in Article 5 in 5.5. It tells me to go to the other law, and there are many cases where I assume that I assume that there's no collision, and that the law regulating the validity of the security, or in the event of enforcement of this digital asset and the form, is kind of out. What else do I like? If I go straight to what I understand, I'm not going to talk about control, custody, or other things that have been dealt very well by my colleagues. I go to security rights, that for movable property it could fit in very well, or even for real estate in the future. I don't know whether in the near future or far away future. What do I like? I like the concept of functional security. I like the fact that it invites us to join in. I don't think there is a regulatory problem with this in Spain, because if we see that the functional guarantee has can be fitted in. For different regulations in Spain, it invites you to adapt to everything, and functional securities as a concept is something that could work, because effectively, if the property right is open, it could fit in the 4 requirements imposed by the General Directorate to create that right. What small obstacle do I see? That what is capable of being registered as movable property is limited objects, and we have to go to 45, 46, and 47 articles in the regulation of non-movable assets to see if they can fit in there or not. Maybe they were reformed in 2015, where the general term of software was included, and maybe there we find the concept of digital asset, but forcing it, we could find a functional equivalence. That's way too much. I'm not going to do that. By regulation or instruction, making a more open concept would allow us to understand any of the digital assets in this sense. And going back to the principles that are given to me, the secure transaction principles 14, 15, 16, and maybe a little bit this principle 17 regarding enforcement, I want to highlight that I like the regulatory void created, and I like to go to the other law. And regarding some of the requirements introduced, I like some decisions. I don't like some decisions much. What is it that I don't like much? That regarding Principle 5, I see a problem regarding securities, in that supplementary chain of established laws that leaves a void, and as Ignacio mentioned this morning, is a voluntary diverging direction. And here I'd like to add a legal concept that is quite innovative. I'm not going to that I learned recently, that would be the law with which the active is closely linked. Why? Because I think it makes sense for the end user. If we're going to tokenized Coke, we have to see what that is about. But there are things that are visually linked to something else. We cannot redefine a usual residency or where the brand is written. This concept is not a concept by me. It comes from a project by ELI and the University of Vienna. And I think that maybe in specific digital assets where there is no globality or cross-bordership as such, we can find a good defense for that third party that is absent that I safeguard. I don't like to go to the law of issuer, because if you go to the law of the issuer, having many companies that act are channels, you cannot skip it, and that's what makes me not want the election law. Finishing off, I'm going to refer to regulation regarding control as an effectiveness method in principle 15 and 16. The Spanish system is a preventive justice system. What does this mean? That it conveys, when it's constituted, all the requirements that enables the persecution of a debtor. In that system, we have the notary public, registrars, and many other legal operators. And making the most of that, we increase fulfillment of different types of regulations. UNIDROIT says in different areas that it's very tedious for the creditor to meet the control procedures or even a registration of deposit, and changes the paradigm in any marketplace beyond its control. I see advantages of control, and it's very immediate, and I liked what some academics suggested of giving control to some sort of third party that is a trustworthy third party, not an oracle, that I don't like the word, that will enable subsequent access to those keys and solves two civil problems that are basic. If we translate it to our ordinary civil legislation, I'm not saying we need to do that, that control and custody are equivalent to possession, but if we wanted to bring it close to our categories, we could solve the problem of competition of possessors, and we would solve problems that could put question different civil regulations. I would like to say that tokenization at the end of the day is similar to a concept that I like a lot, when that in crisis, sudden crisis can change your future, and that can affect you. So I think there are many normative options for that, to diverge marketplaces, to protect fluxes, to see where the market is going. And I think we have to facilitate, from an application point of view, all these commercial ideas regarding anything that can be deviated from that marketplace, that can be self-regulated and that doesn't need to be that protected as that third party that I wish to protect. Thank you very much, Teresa.
No estoy presentando.
I'm not introducing the different participants, and I'm not making reflections that are coming to my mind, because I have many things to comment with all of the things that they're suggesting. But we have the time that we have, and now we are moving to Cristina Sanchez Somoza. She works for Garrigue. She's an expert in these fields, and she's going to tell us her opinion. First of all, I would like to thank the organizers for inviting me. And thank you for reflections on digital assets. And I want to thank Carmen for inviting me. In my case, I'm part of those regulatory lawyers regarding financial regulations. We work with traditional financial entities, and at the moment we are dealing with applying the application of MICA in Spain and in the EU. I wanted to share some reflections because it's true. I'm going to make a very short introduction to explain what MICA is, because the development of the regulation of the cryptoactive markets in 2021, MICA started being drafted, but there were work groups since 2019. So MICA wants to offer services, provide services, or deals with the provision of services. And related to what Gonzalo mentioned, financial entities in Spain provide services for with digital assets, have been providing it for some time. But they were not like funds, etc. They were not regulated. So there was partial regulation 2 years ago on the law of money in regarding to the law money laundering law. So let's oblige providers to be in charge of taxes. So issuers and providers, financial providers, have to follow MICA. So what do the principles mean for us from a practical point of view? When MICA was passed, as it happens with many EU regulations, it regulates corporate government aspects, human resources, transparency obligations, transparency of cryptocurrency. So it's a very ambitious regulation that entails many gaps. Because what we do is to analyze a business, whether it is a bank, a traditional finance company, a fintech. They come with a business and we say, this is what will apply to you or not. So all of these gaps can be integrated with many principles of UNIDROIT. That is, the UNIDROIT principles help us complement definitions that's not given by the EU regulation in the financial market. And in our legal firm, we go through 3 different stages. First of all, we thought that everything was going to depend on the regulation. Then we saw it wasn't the case. But thirdly, we saw that everything could be applied. So, first of all, the principles, the UNIDROIT principles are wider than MICA. So that's the first difference. But in both cases, we see that there's a technology that embodies a right or a technology. So we see that the UNIDROIT rights have paid more attention to technology concepts related to the assets. Because MICA, that's the regulation, what it does is to make many assumptions as for the technology. And for example, it assumes the ownership of crypto assets. It doesn't say anything about them. Even when it refers to transfer has to be translated as a transmission. In MICA, transfer refers to fund transfers, but in this case with crypto assets. So what we thought at first wasn't going to be possible to integrate the transfer of principles has been translated as exchange. Another similarity that's also very wide is the term custody. Financial operators have been working with crypto assets for a long time. Crypto assets have been working for a long time. And what has happened is that, according to my opinion, the advantages they had, that was the lack of the need of intermediaries. They are reduced because with the custodian, you are introducing in a field without intermediaries. You are introducing the custodian that's in charge of registering the ownership, but in a very inexact way. Because MICA talks about user in charge of the crypto asset. So, saying that I understand that the principles of MICA eliminate some advantages that were given by terminology, of course, it makes sense to delete those advantages, to eliminate those advantages. So the concept of custody is very similar, because even if MICA defines it as the safeguarding of the crypto asset and the access means to that crypto asset, so even if we're not introducing more concepts, custody is very similar. So in both cases, it is very similar as a concept. Because what the principles do is saying, if what I say it's custody, that's custody. These are the general criteria that the competent authorities normally take. In Spain, we define what kind of asset it is, and then we see what services are being provided. That's why principles are being so useful, because MICA has not been applied yet. It will be in force on the 30th December this year. So we are working with the competent authorities to define the concepts of MICA, and we are taking the principles into account. Thank you very much, Cristina. I'm sorry I have to stop you, but we have a video call from the States, and we have to respect the schedule. Thank you.
Continuación.
Now we're going to give the floor to Alejandro Vigil. He's a professor at the University of La Habana in Cuba, and he's going to offer the perspective of how this affects them. Well, first of all, I'd like to thank you for inviting me to be able to be here, Carmen. Thank you so much. I'm very grateful, and to the organizing committee. I'd also like to take half a minute, because the situation in Valencia with the floods is something that I want to render tribute to. Last week in La Habana, there was a hurricane We didn't have any victims, many damage, but no one died. These are things that can be predicted, and you have some time, 2-3 days, to prepare. So that what happened to me was that as a result of the hurricane, there was a blackout and we had no electricity. So I don't have the computer couldn't be turned on. So I don't have my presentation here, but whenever I get a chance to recover it, I'll send it to you. Cuba is a different country. Happy to be the only Latin American present here as a participant or as a speaker, because there are other Cuban colleagues. Recently, we've had a legal reform that has been very intense in my country. The procedural code there was a new one in 2021 that amended the procedural system and focused in one single system all the civil, commercial, labor, law aspects. And there's some, it's quite general. And among the important things is that it enables to apply general principles of law in the processing of cases. There's a specific article for that. And there are Cuban rulings where the UNIDROIT principles have been applied regarding commercial or trading contracts. This is not known yet. This is something we need to convey. But there are Cuban rulings where the basis, the foundations of the courts have been the UNIDROIT principles. With this procedural reform, the courts have also the option to bear in mind rulings that have admitted similar criteria by the Supreme Court in the presentation of the lawyers. It's not a precedent, it's not a precedent-based system, but now lawyers in the claims and in the written documents have the option to study previous cases and present a view before the court. In the previous case, this happened this way. I don't know a process regarding digital assets, but that is going to come sooner than later. Regarding this idea, what is the jurisdiction of Cuban courts? Well, mainly related to the topic when the parties are subject to the Cuban court or when the plaintiff has a link with the Cuban territory, or when if there are wider things, we have the Cuban court is to them there. So depending on the case and on the reason, in general terms, in Cuba, we have the free will of the parties, except in the cases that we need to ask the Cuban courts. Last year, we had a presentation at the University of Alicante, and there is legislation additionally in 2022-21 by the Cuban Central Bank regarding virtual assets. They don't call it digital assets, they're called virtual assets, including in general terms digital assets, cryptocurrency, digital currencies, etc. This legislation to some extent acknowledges the existence of this and puts forward the requirements for everything regarding the approval for service providers, of digital service providers, and it establishes that legal entities at national level and at state level are obliged to use only assets that are approved by the Cuban Central Bank. So there is an approval mechanism. So far, there have not been any approvals. Please finish, Alejandro. Very quickly. It leaves open the fact that private employers can use it. Very quickly, I'm going to say that in our participation in my office, we're working on the consultancy to a foreign company transmitting money using blockchain to make transactions in Cuba and to present it before the Cuban Central Bank. We've worked as well with fixed assets tokens. Recently, an employer came to us, a private business person. In Cuba, we have now private corporate companies that wanted to do an investment of capital, of crypto capital, of crypto assets. Well, we need to fulfill the law of the Cuban Central Bank, so we couldn't really transfer it because we had to fulfill everything. As for cash, well, we have a great challenge. We have to open our eyes and see the whole paradigm that we have ahead of us. We have to review the Cuban legislation, and we have to try to propose and promote the incorporation into Cuban legislation of UNIDROIT principles. Thank you very much. Thank you, Alejandro. I'm sorry I had to cut you.
We had Luis Jimeno, but now Juan Carlos is coming from the same company, Mocrypto. And what can you tell us? Thank you, Carmen. Thanks to all of you. Thank you for organizing this conference. Thank you, and thanks to all of your team for the wonderful work. From Mocrypto, our work in the world of cryptocurrencies is for cryptocurrency owners to be happy, because it seems that if you own a cryptocurrency, it's like an investment. They think that everything is correct, but many of them think, what can I do with this currency? As Gonzalo was mentioning, it can be used to purchase properties, and that's something that's a reality, but people are still scared. Maybe those of us here, we're more used to work in a crypto world, but if you go out to the street and you do a survey, you would be scared of what people think about cryptocurrency. And what we do is to try to take that idea to reality, to turn it into reality. And what we do is for people to be able to use cryptocurrency to purchase a property. I'm going to try to keep it short, and I'll tell you a 1 minute long story. I just wanted to tell you that Mocrypto offers you the possibility to purchase properties. The procedure is simple, but at the same time it's complex to follow it. I mean that the whole process, it's easy, but many things have to be taken into account for our colleagues, notaries, to be able to sign, and for registrar to register it. And everything has to be 100% regulated and legal. The most important aspect is the money laundering report, money laundering prevention report. I'm not going to go into detail, but it's true that this is done in a reinforced way, because when someone coming from Russia, Ukraine, or is coming from a hot place in the world, in a conflict area in the world, and they want to do the purchase in a transparent way, the report has to be very detailed so that taxpayers or the bank we work with, Bank to Me, because they're from Elche too, as we are. And as Carmen said, it's a very interesting crypto situation in the area. So with this report, we have to make sure that everything is clear and legal. Once this full analysis is finished, it's sent to the notary. We work with Cesar Belda, who's one of the notaries that's more specialized in Spain within the crypto world. And then it goes to the crypto bank B2Me. Then we exchange currency into euros. And then it's done in a normal way. That's why we are good friends with registrars, because everything gets there in euros and nothing happens. Within a simple but complex system at the same time, we try to help these people to be able to use their crypto assets to purchase a property. And I'm going to tell you the story, and I'm going to move to the following participant. The story was that a client who works for a very important multinational company, part of her wage, she's paid that wage in Bitcoin, and she left them in her wallet. And one day she heard that she could purchase a property with cryptocurrency. She got in touch with a real estate company. The real estate company got in touch with us. And this person decided to go ahead with the purchase because she thought that was something that was lost. But she understood that this was something that was a fraud. And when she went to the notary public, she thought that everything was false, that everything was like that we were all actors, because it was a very expensive property. And until the moment this woman went to see the villa with the keys, and she got hold of the keys, she started crying at that moment, because her dream became true, or was true. That house was near Benidorm, and she couldn't believe that she couldn't make her dream come true. I don't know if it was Calpe. No, it was near Calpe. It was in Javier. What happens? So Imo Crypto helps taking this world that is very interesting to turn it into a reality. And with this story, we see that we can help people to make their dreams come true. Okay, thank you very much for saying that dreams come true. And this way we're going to get to be on time. Now we're getting to Laura Vicente Gomez, partner of GESEM. I've got a very good relationship with Laura. We have been working for a long time. Laura, you've got the floor.
Thank you very much for inviting us. Thank you for letting us sponsor this kind of fora. We're more present in the, I'm not going to say the real world, but I'm going to use the term because I was commenting it before with my colleagues. When we listen to the magnitude of the papers, the deepness of all the papers, well, we have a consultancy firm. It's a family business. My father gave me part of it. Now I have 5 partners, and one of his ideas was to have a stock agency. It was a great idea. It's a line of work that works very well. And we're also located in Elche. And within these initiatives, when we were called to validate a white paper, you can imagine that the first time we received this request, we didn't believe it. So this is the real world that we received. So listening to all the work, all the people working on this, it's been a pleasure to be here and sponsor this forum that brings those of us that are waiting for the Mint company to authorize us. We understand the hard work that you put into it. So the principles, the question was about the principles. I'm sure they help for the commercial reality. Because as Cristina was saying before, conversations with the Mint entity in Spain are not easy because they ask us, how are you going to do this? And well, the principles help us reply as to how we're going to proceed. And we're going to do it together with people. We've been working with Carmen in depth because we don't control technology that much before. Well, I've written down some quotes. At the end, we are the user that is going to control the crypto asset, and that is a responsibility. I was commenting before as well that insurance companies, because that's the reality of our conversations, we have to talk with the insurance company and say, I'm going to expand my leaflet and my activities to this, to include this. And they say, I don't know what this is. I don't know how to cover liability here. And that's what we're finding. Financial markets, Professor Reyes was saying this before, and they're going to proliferate and going to develop very quickly because they are, these marketplaces are ready and have a system that enables this hastiness. And then we go to the tangible world and we talk with notaries public and registrars. We focus on the end consumer. If we look back, the whole ESIS scheme is born to protect the customer or the consumer. When we are called by someone, say, can you validate this white paper? Well, translated into reality, it means someone is going to buy a token. They need to understand that what they're buying, who's behind it, what is it worth, how is this person going to turn these euros in crypto assets to pay. So complexity for a user in the street is so large, so big that it has to be taken care of, and that's the role that I hope our stock agency is going to play if we're authorized soon. If they ask us, why do you dare to do this? Well, someone's got to start, and I'm very proud to be three of us are in Elche, but I think Spain is playing a very important role in this development. The fact that the principles are there and that we're working on its translation, it says a lot of us. So thank you very much for inviting me here and for giving me the opportunity to listen to all this. Thank you very much. I think we mission accomplished. We have time for 2 questions. So now I invite you to ask questions or open discussion. Any questions? Yesterday I was commenting with Professor Marina Echevarria that I liked her explanation a lot because, and this comparison I've mentioned it, is as if we all lived in a tube, in a closed tube, and everything, and there was the process and procedure, and all of a sudden everything is focused in this tube, and all of a sudden we open it and we see that there's lots of confetti, lots of we can all participate. It doesn't mean that notaries, public or registrars are going to disappear, but we need to translate the new role. But you have to say, well, are you going to be notaries, public or registrars? No, that's not the point, because that's impossible. So in this explanation of the principle, in this conversion to the real world, each concept on digital assets, their financial assets, there are many things. So I think the key is there for the consumer to understand it and doesn't see like all sorts of things that he or she doesn't understand, and can make their dreams come true. I support what has been just said by my colleague, because none of the regulated instruments gets into the legal nature. They don't establish typologies, or they don't even distinguish between the three basic elements. Yesterday we could hear Teresa Rodriguez de las Heras talking. She has different publications representing different institutions. But none of those types have been secured. We need to define legal natures, and once we assume them, we have to see each legislation, and if there's something that doesn't fit in, maybe we need to regulate it again. But we need to bring closer what the unknown to the known. Thank you very much. Marina wishes to take the floor very briefly. Yes, the question, Laura or Cristina, that you're in this field. How do you solve materialization of the position of the principles, in the sense that if you're a custodian from a legal point of view, it's very interesting, but in the from a technical point of view, it's not that interesting. So I think you are looking for sub-custodian positions, and what type of institutions are you addressing? From the point of view of regulations, being sub-custodian doesn't solve anything when preventing the regulatory burden, because the rule, what it does is it catches all the situations where that custody situation takes place. What we call BAS is the custody register of people that exchange cryptocurrency for cryptocurrency. These are registry subjects, and would, according to the criterion of the Bank of Spain, those used as sub-custodians, because sometimes there's not enough technology to to have the custody of crypto assets, and sometimes they have a relationship with the client. They hire the custody as custodians, and they are the ones that have the adequate technology. So what the regulator was saying, well, I don't mind if there's no contractual direction, but the sub-custodian has to be registered as a custodian. So from a regulatory point of view, you are not exempt of the burden, even if you're a sub-custodian, unless you are only a technological service provider. The Mint institution of Spain, we've told them that we don't have the human resources within the company to develop that. And what they've told us is that we need to bear in mind that the issuer can choose the blockchain. I'm going to think in DLT terms. The only thing that you have to be capable of doing is you don't need to be capable of developing that or custodying it. You have to be capable of entering and verifying each step. And that's where we can talk about the double signature, because nobody's going to, well, somebody could give you the keys, all the keys, but there we were thinking of us as someone managing the possessions of someone. If that person dies, you are in charge of everything that person had, the will of that person. So this is affecting the consumer, the equity, and the Mint entity. And how can we verify this? Well, something I just thought of, we always think of hard custody. But we are considering some projects on custody under MICA on cold custody. They use hardware and they have it custodied in a room, and everything gets complicated there because you are a custodian of a custodian, a proper custodian. Okay. We're going to stop here. We have Neil Cohen waiting for us. David is going to present him. Thank you very much. Please, a round of applause.